Good afternoon, everybody. Thank you for attending today's session on fair housing. Just a couple reminders before we get started. Please keep your microphones and cameras off during the presentation to limit distraction. If you have a question, please type it in the chat box and I will relay them to our presenter as we go along through today's presentation. And lastly, if you need a certificate of completion for today's training, please email Stacy at the end of the presentation and she will get that sent out to you. This is being recorded, so if you have staff members or colleagues that are unable to attend today's training, there will be a recording for it. So on that note, I will hand it over to Kirsten.
Thanks, Kylie. So I'm Kirsten Small. I am one of the investigators with the North Dakota Department of Labor and Human Rights. I have been an investigator here just coming up on 9 years at the beginning of May, done a couple hundred investigations related to discrimination, same with wage and hour complaints. I do a lot of our presentations. Actually, I'm one of the few people in the world that actually likes doing presentations. So hopefully we can give you guys some great information about kind of what our department handles, some of those common fair housing issues that we see, as well as some things that are kind of trending or things that are happening more frequently, and hopefully ways to prevent them. I know it can be a little bit tedious going through 2 hours, sitting through listening to somebody who enforces laws for the government about fair housing laws. So hopefully we'll make it not as tedious. Hopefully it'll be interesting and you guys can gather some additional information as we go along. If you guys have any questions, absolutely put them in the chat, let me know. But like I said, hopefully we won't make it too difficult, especially after lunch hour. It's getting to that time of day where everyone kind of needs a nap. So hopefully I'll provide you some great information as we go along. So to begin with, let's talk a little bit about what we'll be discussing today. So first and foremost, like I said, I just want to go through a little bit more about what the department does. When I first started at the department, I truthfully had no idea what the department exactly handled, what it was comprised of. So I'll provide you a little bit more information about what the department exactly is. Then we'll dive into a little bit more of why most of us are here today for, which is what exactly is housing discrimination? What does that mean? What does that entail? Kind of go through what the laws are that specifically relate to fair housing. There's 2 major laws that we deal with when it comes to fair housing. So we'll talk through those. We'll talk a little bit about statistics and facts related to fair housing, and then walk through some of those common issues. Again, hopefully shedding some light onto things that are common issues we see at the department, best practices on how to avoid those if they do come up. I'll also walk through and explain a little bit further about the department's actual process. So if a complaint is filed, kind of what to expect or what it is that the department looks at when it comes to those complaints. So just starting off, we'll talk a little bit, like I said, about what the department is. So the Department of Labor and Human Rights, it actually started as an entity of the Department of Agriculture. And until 1989, the Labor Commissioner, who is kind of the main boss, if you will, or the main leader of the Department of Labor and Human Rights, that position until 1989 was an elected position. Since then, it has been an appointed position by the governor. Our current labor commissioner is Nathan Spajovic, and we've with the Department of Labor, one thing that always kind of shocked me or surprised me when I first started, and it oftentimes surprises a lot of people, is it is not a very large department. We actually just hired another investigator, but we have a total of 6 investigators for the entire state of North Dakota. We have an admin employee, so administrative assistant that kind of handles a lot of our paperwork side of things, and then we have the human rights director who oversees most of the discrimination aspects of it, the labor commissioner, who oversees kind of the entirety of the department, and then a director of operations that handles more of the HR, kind of the management side of things. So as a whole, our entire department can fit into one very small room. We can pretty much have team meetings at the equivalent of a dining room table, which again always surprised me, and it kind of is surprising to a lot of people because we handle a lot of cases per year when it comes to whether it be wage and hour complaints or discrimination complaints. The department as a whole, we have three main pillars that we handle. So we have what we call the wage and hour division, the human rights division, and then things like this, the education and awareness. We're talking about wage and hour. That's going to be related to pay. So it's going to be related to minimum wage and overtime provisions. We handle the provisions related to child labor, labor unions, employment agencies, wage collection, independent contractor verifications, and just really anything that's related to the piece of the Century Code and Administrative Code related to wages. The Human Rights Division, that's what we all think about when we talk about discrimination. So that's going to be discrimination in employment, discrimination in housing, public service and public accommodation, and credit transactions. And then that last pillar, the education awareness, that's things like this. We do a lot of presentations and booths, just outreach to the general public to have some sort of awareness of what the labor laws and the human rights laws are in the state, as well as just provide general information, hopefully to prevent any of those claims from coming across our desks. When you talk about the Human Rights Division, there's basically four main laws that we handle related to the human rights side of things. And again, this is the discrimination side. So the first piece of the law that we handle on the human rights side is going to be the Human Rights Act. That is related to discrimination in employment, discrimination in public services and public accommodations, and then credit transactions. So that's what all is covered under that Human Rights Act. Then the second piece of the law, that's what we'll talk a lot about today, which is that North Dakota Housing Discrimination Act. As it pretty clearly it explains, that is discrimination in housing. So discrimination in the sale, rentals, anything related to housing, that's going to fall under that North Dakota Housing Discrimination Act. The last two laws up there, those are specifically related to retaliation, most commonly in employment. So that North Dakota whistleblower law, that's going to be if an employee reports some kind of law violation or is requested to participate in some sort of legal proceeding or maybe investigation. And as a result of that, the employer takes some sort of retaliatory action against them. So again, what we might consider a whistleblower, that is what that law would cover. And then lastly, the North Dakota Public Employee Relations Act, very similar to the Whistleblower Act or the whistleblower law, but that is very specific to only public employees, and it has very specific provisions as far as how that employee reports the potential law violation, who they report it to. So there's a lot more limited parameters when it comes to that, but those last two laws are related to retaliation specifically in employment. When we talk about the wage and hour, and I'll just kind of briefly go over this, like I said, to give you a better understanding of some of the pieces that we do handle. So a lot of complaints that we see come across our desk with regards to that wage and hour division is going to be wages for work performed. So this is unpaid wages, maybe final paychecks that have not been paid out. It could be issues related to vacation wages, maybe deductions from pay. All of those would be considered and kind of calculated as part of that wages for work performed. Same with hours of work issues. So this again could be related to not being paid the proper amount of hours worked. It could be related to rates of pay issues. All of those will fall under that wage and hour category. Youth employment, we do have specific laws on the state side of things and the federal side of what 14 and 15-year-old employees and any employees under 18 can perform in the state. And so we have specifically for 14 and 15-year-olds, they have to complete what we call a youth employment certificate in order to perform work in the state. And so we process all of those applications or all of those forms related to youth employment, as well as the enforcement of ensuring that employees are performing the works that are permissible for what their age is. We do have limited jurisdiction over independent contractors. We do not have a jurisdiction to look into independent contractor wage issues, but we do have the authority to determine if the employment relationship is truly that of an employee-employer or that of an independent contractor and then their company that they work for. So we do have authority to look into those kind of relationships and determine if they truly are an employment relationship with an employer employee or if they're an actual independent contractor relationship. We also handled certificates for any employees that receive below minimum wage. So there are certain employees that can receive less than what the state minimum wage of $7.25. There's very limited provisions on who can be paid less than that $7.25, but we do handle those forms, those requests of employees that are receiving less than what the minimum wage is. And then lastly, that employment agency licensing. We don't see a lot of this, but if an employment agency comes to the state and performs under certain conditions, they may have to submit an application with our agency or documentation with our agency in order to perform employment agency work within the state. The wage and hour piece of it, we see more wage and hour complaints as a whole, and you'll see that as we go into these next slides, than human rights complaints. But in the last biennium, we received about 722 cases filed and 492 cases closed. Again, this is for a 2-year period. So if you think about prior to, honestly, just yesterday when we had a new employee start, we had 5 investigators working through all of those complaints. So that is a substantial amount of claims for such a limited amount of staff. So sometimes when we have employers or employees questioning, well, it's been a while since it's been assigned, that's the reason why. Just so manpower, it can be difficult to get through all of those cases. And with the wage and hour and the human rights, we see a lot of ebbs and flows when it comes to the amount of cases filed. So it seems like certain years, whether it be for certain conditions or kind of certain things happening, whether it be just in the environment right now, I think because of the amount of inflation, things like that, we tend to see a lot more cases filed, whether it be on the human rights side of things or the wage and hour, solely because it's just, there's a lot of things happening. There's kind of a lot of emotion that's happening internally for a lot of people, a lot of stressors, and that usually ends up having a lot more complaints come through our office. Likewise, when we had the oil boom, as you may expect, we had a huge influx of cases filed. So it kind of ebbs and flows depending on what's happening in the current kind of trajectory of things in, whether it be in the environment or just kind of statistically what's happening. With regards to the human rights side of things, again, this is going to be discrimination. So this we do see substantially less than with the wage and hour, but this is going to be related to our employment discrimination, public service and public accommodation discrimination, credit transaction discrimination, and housing discrimination. When we talk about public service and public accommodation, we're talking about public service could be a great example of that could be like a city water company. So the city of Bismarck water, or it might be for a police department. So the city of Fargo Police Department, anything that would offer some sort of service to the public that the individual believes that they're being discriminated against based on. Public accommodation, this is going to be more of what we think of businesses. So it could be that an individual went into Walmart to seek some sort of product, and as a result, during their time in the store, they were discriminated against. Maybe they were denied the ability to purchase the items. That would be an example of a public accommodation. So when we talk about public service and public accommodation, it's more of anything related to the public realm outside of employment or housing. When we look at these cases for the amount of cases filed, we had 432 cases filed and 333 cases closed. Again, that's substantially less than the wage and hour complaints. But when we look at this number, so of the cases that were filed, 308 of these are employment discrimination. So when you think about kind of on the realm of how many cases are filed under each piece, the employment discrimination is going going to be by far the most filed on category of those human rights issues. Housing, we had 52 cases that were filed in that 432 number. Public service and public accommodation, we had 16 of them. And then we had 56 complaints of retaliation, or those whistleblower laws that I had spoken about. That's related to those. We call them a complaint of retaliation. That we had 56 of those in that 432 number. So again, employment discrimination by far the most filed on item in human rights, followed pretty closely by housing, and then public service and public accommodation thereafter. So again, obviously, we are here to talk specifically and most detailed about housing discrimination. So what is housing discrimination? When it comes to things like discrimination or harassment, there's a dictionary definition and then the legal definition. And so it's something that's commonly discussed, but when we're talking about it in the realm of what we handle, what exactly is that definition? It's treating someone differently in the sale or rental of housing because of a person's membership in a protected category. So even when we're talking about this, even under the law, if people who don't necessarily mean to discriminate, they could be responsible for discrimination if they are treating someone differently in that sale or rental, or the privileges in the sale or rental of the housing solely based on the individual's protected category. So there's two main laws that we handle with relation to those fair housing laws. The first one being the Fair Housing Act of 1968, and then the second one being the North Dakota Housing Discrimination Act of 1999. The Fair Housing Act of 1968, that's going to be the federal side of the law. The law itself was passed approximately 7 days after the assassination of Dr. Martin Luther King Jr. And basically, kind of what the entire purpose of that fair housing law and all of its amendments and changes since that 1968 initial date is to ensure fair housing for all, to ensure that there's not any sort of bias, again, whether it comes to the sale, the rental, or any sort of privileges in housing because of an individual's protected class. The North Dakota Housing Discrimination Act is going to be what we call substantially equivalent to that Fair Housing Act of 1968, which all that means is that basically the North Dakota law is equivalent to the federal law. We have a partnership with HUD, which is the federal side of things, Housing and Urban Development. And with that agreement of kind of having these, we're able to investigate cases for them. They're able to investigate cases for us. And that's why we have that substantially equivalent law. Basically, it's just that to ensure that regardless of whether the federal side of things looks at it or the state side things, State Department looks at it, it's going to have an equivalent outcome because our laws are that similar status as the federal side of things. When we do have that work sharing agreement, like I said, instead of having two separate investigations, we're able to have one investigation by one of the departments, whether it's by our department or by the federal. Had a sneeze, sorry. So when we talk about having those investigations, generally speaking, when we conduct an investigation that is what we call dual filed or filed with HUD as well as our office, HUD will generally adopt the findings that we make. So they'll generally basically the investigation is resolved for both parties or both agencies, I guess, as the resolution that we found. We do have kind of an audit system with the federal department or the federal HUD, and basically that means that they can review our cases to ensure compliance, ensure again that they are substantially equivalent. But generally speaking, the same exact type of investigation is going to happen whether it came from directly from HUD or from our office because we have that partnership. So what exactly do fair housing laws do? It makes it unlawful to treat someone differently in the sale or rental of housing because of that person's membership in a protected category, especially when it comes to landlords, management companies, even rental property owners. Sometimes it can feel like these fair housing laws are just another hurdle, extra paperwork, extra burden that the landlord or the management company has to deal with when it comes to any sort of issues, whether it's reasonable accommodation requests or, if a complaint is filed, sometimes it can feel very burdensome to provide a response. But the entire purpose behind these laws truly is to level that playing field and to ensure that there is fair housing for all, regardless of that individual's protected category. It can certainly reduce homelessness in certain types of populations or certain types of groups. It can ensure just, again, fairness in the entirety of the process. I always say kind of it's easy to see it as a bit of a burden unless you're in that situation. And so sometimes I think it can help perspective wise to understand why the fair housing laws even came to be and what they're existent for. And then it's a little easier to understand, again, if a complaint is filed, this is just part of the process, is going through the motions. And sometimes there is no discriminatory act that has occurred even when somebody has filed a complaint, but really taking a look at your practices, your policies to ensure that everyone is being treated similarly, or they're not specifically being singled out solely because of their membership in that protected class. When we talk about those protected categories, what exactly are we talking about? Being treated differently from one neighbor to another is one thing, but being treated differently because of your specific category is where it becomes problematic. So under the Fair Housing Act, which again, this is the federal side of things, the protected categories are color, race, familial status, which is any individual that has children under the age of 18. Maybe they're obtaining their children, or some sort of they're gaining custody of children under the age of 18, potentially if they're pregnant, or if they are individuals that the children under 18 are living with a legal guardian of some sort. That's what familial status is. National origin, color, religion, disability, and sex. So those, again, are all of the federal protected categories. And the big thing here, again, to remember is if an individual is being treated differently because of, for example, their national origin or because of their disability, those are where the Fair Housing Act laws will come into play. When we talk about the North Dakota Housing Discrimination Act, we have all of those same protected categories that the Fair Housing Act does, but we also have a few additional categories. The big thing with again, that substantial equivalency, or having that similar law as the federal side of things, we can have more of the law, but we just can't have less. So specifically in North Dakota, there are a few additional categories that have protections that are not just kind of that bare minimum that the federal Fair Housing Act provides for. And that is the individuals with the receipt of public assistance. So this may be because individuals receive maybe North Dakota rent help because they receive Section 8, that they cannot be discriminated against based solely on the fact that they receive public assistance. That is one of our state protected categories. Age is another protected category that is not on the federal side, but it is on the state side. And we talk about age, it's solely based on individuals age 40 and over. So younger individuals are not, that in of itself is not a protected category. The protected category is age 40 and over. The domestic violence issue, that is one that it's our newest protected category, and it's very specific. So it's solely for an individual that is a victim of domestic violence that's under certain state programs, and they cannot be discriminated against based on their kind of position within that state program. So very limited. We haven't, since it has been enacted, we haven't seen any come across our office that fell into that category, just again, based on what the law exactly states, but that is our newest protected category. And then lastly, marital status. So if the individual is married, unmarried, divorced, any of those protected those areas, they cannot be discriminated against because of that reason. So they can't be denied housing because they're divorced. They cannot be denied housing because they are single. So those are those 4 protected categories that are solely for the North Dakota side of things. So who or what is covered? When we look at a complaint comes across our desk. Some of the first things that we look at is, first question, does the complainant fall under one of the protected categories? So is the individual alleging discrimination based on one of those protected categories? Is the dwelling or the housing related transaction covered under the law? So when we look at that, there's a lot of things that go into it, but we look at, are they alleging some sort of discriminatory act of a rental, a sale, or other housing related transaction? And then lastly, is a respondent themselves covered under the law? So are there exemptions? There certainly can be. So when we talk about the exemptions, there are exemptions from some of these fair housing laws. Specifically, there's 4 major exemptions when it comes to housing discrimination. So the first one would be what we call the Mrs. Murphy exemption. This is a very specific exemption of if the rental has 4 or fewer rental units and the owner lives in one of those units. So the easiest way I can kind of explain it is, let's say you have a 4-plex. It's the only building you own. It's the only building that you have any rental properties at, and you yourself live in the building. So one of the 4 units is occupied by yourself. That could fall under that Mrs. Murphy's. When it comes to the Mrs. Murphy's exemption, it is something that is closely looked at. It can't be, let's say the mother is the one that owns the building, but her son really is the one that does most of the paperwork, most of the rental items, and he lives within the property. That's not going to fall under that exemption because the owner has to be proven to live in the property. So it's a very specific exemption and has to be proven as such. There are some religious exemptions, but the religion can't discriminate in the membership based on race, color, or national origin. So although they can say only individuals of this certain religion can stay here, they can't exempt people because of their race, color, or national origin. Same with private clubs. They can have restrictions as private clubs, but again, they can't discriminate based on that race, color, or national origin. So this would be something like a members only type of category. So if an individual is renting from a property that has only members are allowed to rent from, they can indeed have some of those restrictions related to any of the protected categories outside of race, color, or national origin. And then lastly is the housing for elderly exempt. And this one relates to specifically for familial status and age for developments. So it may be like a 55 plus community, those type of things. But again, it's going to be just like the Mrs. Murphy, it's looked at very closely. So if any respondent does indicate some sort of exemption, again, it's something we look at very closely because it's not just we take your word for it. Oh, yep, they say that they're exempt, they must be. We really want the documentation behind it and ensure that that is within compliance of the law. So now we'll go a little bit into the statistics and facts. So break down the numbers a little bit of the housing complaints that are filed with our department and what common outcomes are for those cases. So for the last biennium, this is the 2021 through 2023, we had a total of the 46 claims closed, and the previous biennium I included on there as well. We actually had 48 claims closed, but those are the previous biennium, just to give you kind of what you see from year to year of what those cases look like. We had 19 cases of those 46 that were what we call conciliated, and we'll talk a little bit more about conciliation. But basically, conciliated claims could be that a claim was filed with our department and some sort of resolution was reached between the parties. We emphasize conciliation throughout the process, just basically trying to allow for the parties to resolve the issues before it gets to the point of a completion of investigation. And sometimes it can be simple things like granting a reasonable accommodation. Sometimes it can be a positive rental reference. Occasionally it could be a monetary amount, additional training for the respondent. There's a number of different factors that could go into a conciliation agreement, but it's basically an informal way of resolving the complaint prior to the completion of an investigation. 13 of those cases, we had what we call no reasonable cause, which means that based on the facts and evidence, we did not believe a violation of the law occurred. 4 of them were reasonable cause, which means 4 of those cases we did believe a violation of the law occurred. Again, if you look at those 19 and 2021 biennium numbers, we had none during that 2-year period that were a reasonable cause. So it can certainly ebb and flow. It can be fluctuant. Every case is substantially different. Every case is very unique in the fact that it's all based on the individual facts and circumstances, and we compare that to the state and the federal law. So really that number of what we believe violations of the law occurred can certainly fluctuate each biennium, as you can see. 4 of the complaints were dismissed for various reasons. They could be dismissed due to lack of cooperation from the complainant. It could be for some other reason, but generally it would be if the complainant does not maintain contact with our department in order to proceed forward with the investigation. 0 of the cases we had were referred to HUD. Occasionally, they may be referred to HUD for jurisdictional reasons. Maybe we have conflict reasons, whatever the case may be, but we didn't have any that were referred to HUD to investigate. We did have 4 that were withdrawn with resolution. This, again, similar to conciliation in the fact that the complainant may contact us and say, actually, I filed the complaint, but we were able to resolve it. We came to some sort of resolution. I'm just going to withdraw my complaint. Likewise, they can withdraw without resolution. We had 2 of those in the last biennium, and that can be something as simple as, I filed this complaint, but I moved from the apartment and I don't want to move forward with the investigation. I don't want to continue to go through this. I'm, not living there anymore, whatever the case may be, but they can withdraw it without actually having sought some sort of resolution. So of those claims that we just talked about, kind of what those closures were, what were the basis or what were the protected categories that the individuals alleged were being violated? So of the complaints we had, 28 of them were filed on some sort of disability. 9 of them were filed with a basis of retaliation included. 10, the receipt of public assistance. 2, familial status. 1, national origin. 1, color. 1, age. 4, sex. 8, race, and 1, marital status. As you can see, this number does not equate to the amount of cases that we had filed. So you can assume that the categories occasionally can have multiple bases on a complaint. So if the individual believes that they were denied a reasonable accommodation based on their disability, and as a result of them requesting that accommodation, they were retaliated against, that could have disability and retaliation both filed on the same issue. If the individual believes that they were being denied rental because of their race, color, and national origin, you could have 3 different bases on one complaint. So when we talk about the number of items on this list, the reason there are more than actual complaints filed is because oftentimes complaints contain numerous allegations or different bases depending on what the complaint contains. So obviously disability most filed on item by far in our department. So what exactly is that definition of disability? So again, we talk about what that dictionary definition is versus what the legal definition is. We have a lot of complaints that come through our department that an individual believes that they're disabled for many reasons, but they may believe that I receive Social Security disability benefits, therefore I must be disabled. We look solely at the Fair Housing Act and the North Dakota Century Code when it comes to the definition of disability. So the individual, whoever is filing, does have to demonstrate that they fall under this legal definition. So they have to demonstrate that the individual must meet the definition under the law, an individual who A, has a physical or mental impairment that substantially limits a major life activity, or B, has a record or history of such an impairment, or C, is regarded as having as an individual with such impairment. When it comes to the last one, that regarded as, an example of that could be, let's say the individual does not have any diagnosed conditions. Maybe they don't have any, let's say the issue is maybe mental health, schizophrenia, or something of the sort. And their family has a history of that. They have numerous family members that have been diagnosed with schizophrenia, but they have not, nor do they indicate that they do have it in any way, shape, or form. But the respondent treats them as if they did have it. That could be being regarded as. So when we look at this definition of disability, we do look at it closely. The Fair Housing Act is, or the North Dakota Fair Housing Act, we do have some pieces of it that actually take into account mitigating measures. So if the individual is taking maybe medication or has some sort of assistive devices that reduce or eliminates that substantial impairment, that may not necessarily constitute as being a disability. We see a lot of individuals that come through a department that have injuries, very short-term injuries. Those may not be classified as a true disability under our law, but again, those are all assessments that would be made during an investigation. So it can only be discrimination if the person has a disability, right? Not exactly. So it could be that the individual believes that they're being treated differently because of their personal disability, but it may also be that they believe that they're being treated differently based on their association with a person with a disability. So let's say if an individual, maybe a couple owns, or they're renting a unit, and their mother-in-law comes to move in. She's on the lease, but she's not necessarily the main leasee. She's not the individual who's basically co-signed for the apartment, and she has a disability. It may be that the individuals are being treated differently because of their association with that individual with a disability. It could be somebody who's visiting this facility. If they're requesting some sort of accommodation, or need some sort of accommodation related to their disability, you may see things that come across that may negatively impact your tenant, but aren't necessarily due to specifically your tenant's disability. So that's the disability itself. The individual does not always have to actually have a disability. The other example that could certainly come into play is testing situations. So if a tester calls and says, I have 12 service animals, can I live there? And the instant response is no, that could be, they could file on that action, even though they may themselves not have a specific disability because it was a testing case. So disabilities, it's a broad spectrum. It's not as simple as you can quite tell from the definition. It's not as easy as demonstrating they have a visual impairment or not. There's a lot of disabilities, whether they're mental illness, maybe it's some sort of heart condition, maybe some sort of brain injury, or even something like diabetes that may be a substantially limiting impairment or a disability under the law, but it's not always what you may think of right away or see visually that the individual has outright a disability. So what does this all mean and how does that affect you? Obviously, we've talked a lot about the technical and the legal definitions of what exactly a disability is, but what does that actually mean in a practical scenario? Sometimes the legal jargon, and I don't fault anyone because even for myself, going through these laws day in and day out, it can be extremely daunting. It can be very difficult to understand exactly what it is that are your expectations, specifically when it comes to individuals with disabilities, or more specifically for reasonable accommodations that we see quite frequently. So reasonable accommodations. Reasonable accommodations are changes, exceptions, or adjustments to a rule, policy, practice, or service. They can be a number of things. I mean, the list could literally be endless on what kind of accommodations may be requested, and they would be all tied to individuals' disabilities. Fair housing laws do require that reasonable accommodations for individuals be made for individuals, again, with disabilities. Basically, they, again, are just requirements that are there. They're the fair housing laws there to level that playing field, to ensure that all of your tenants have equal advantages, equal enjoyments of the property, regardless of whether or not they have a disability, regardless of whatever their protected class is. So when you think about reasonable accommodations, that's what they're there for. They're to ensure kind of the level field for all tenants, regardless of whether they have a disability or not. Failure to provide those reasonable accommodations may constitute a discrimination on the basis of disability. And we'll talk a lot more about reasonable accommodations. Like I said, we see these the most frequently filed in our department. Disability itself is the most filed on basis, but reasonable accommodation is the most filed on item within that. So the first sentence says it all. Most commonly filed on issue in our department and with HUD. These are extremely common. There's very few cases that are on my desk right now for housing discrimination issues that do not, in some way, shape, or form, handle reasonable accommodation. It's very common. We see a lot of concerns and questions related to it. The requests, they can be made by current or prospective applicants and residents. So they may be by current tenants. They may be requests to how rent is deposited, or maybe it's requests to have an assistance animal or some sort of assistance with maybe taking the garbage to a garbage. Those can be current tenant issues, but they could also be for prospective applicants, whether it be assistance in the application process, maybe some unique circumstances on how they handle certain applications, or just general requests that they may not always be for the specific tenant that's actually residing there at that moment, but they may be leading up to residing there. The respondent should request or should address these requests in a timely manner. You'll see this quite frequently as I go through this. Having those untimely delays certainly can be problematic when it comes to responding to reasonable accommodation requests. So the request, it may impact just that individual's property and residence, but it also could potentially impact common areas as well, whether it's entering and exiting, maybe it's the installation of potentially a different, maybe a door or something that would be more easily accessible for individuals. It certainly can impact common areas as much as it does the individual's property themselves. So there is a difference between a reasonable accommodation and a modification. So again, the accommodation, that's related to those policies, those practices. When it comes to a modification, these are those structural changes made to a unit or common area for individuals with disability. This could be widening the doorways, adding ramps, installing grab bars, lowering kitchen cabinets, altering walkways. Those might be considered more of reasonable modifications. And they're going to have the similar undue hardship test that even reasonable accommodations would require, as far as ensuring that they are, if the respondent is saying it was an undue hardship, we're looking at, was it truly an undue hardship? Was it were they incapable of being able to provide that modification for whatever reason? When we talk about the modifications, one thing about them is when they when the individual leaves the property, they do have, under the fair housing law, they do have an obligation to return the property to original condition. So again, major changes or major differences between an accommodation versus a modification. Unfortunately, they have such similar words, verbiage of each one, but a reasonable accommodation is going to be that alteration to a change, a rule, policy, or practice. This one, the costs are going to be paid by the landlord, regardless of whether it's public or private. This is going to be, again, those alterations to what the kind of standard practice is. Sometimes there's going to be costs associated with reasonable accommodation, not as frequently, generally speaking, as a modification, but there could be costs that are associated, and those would be paid by the landlord. Whereas modification, that's going to be the removal of those actual physical barriers. Those costs are going to be paid by the tenant unless the property receives some sort of federal funds. So if they're a federally supported housing program, Section 504 is kind of what it's considered under. If they are one of those properties, they may have to pay for those modifications. It's really going to just depend on kind of what the federal funding is in that situation. Accommodation and modification requests, they do not need to be on a specific form or in specific magic words. When it comes to kind of going through these requests, a lot of times we see, well, we were only going to grant it if they provided it to us on our form. The forms can absolutely be helpful. The tenants oftentimes are willing to certainly go through those and provide them. But if the information that you have been provided does indicate a reasonable accommodation request, the respondent cannot require an individual to make the request on a specific form solely as kind of a condition of that accommodation. Additionally, it's not going to be, generally speaking, in wonderful wording. I would say reasonable accommodation is something that's certainly more prevalent in our just everyday verbiage, but as a whole, there's not going to be very many situations where a tenant will come up to you and say, I am a person with a disability under the law. I'm requesting a reasonable accommodation as a result of my disability, and this is specifically what I am requesting. It's sometimes you're going to have to read between the lines a little bit. You certainly may have to engage in that interactive process to really understand what they're requesting, what the limitation is, and how to reduce or eliminate that barrier because of their disability. So reasonable accommodation, reasonable modification. What exactly is reasonable? Basically, under the law, the big things that we're looking at is that it does not cause some sort of undue hardship, that it would not impose some sort of undue financial or administrative burden. So, and again, this is going to be something that we'd look at closely. So does the request, is it going to be really just infeasible because of the costs that's associated with it? Or will you have to hire additional staff to be able to provide this accommodation? Things like that. Those might be those financial or administrative burdens that really make it no longer a reasonable accommodation. The other part of it, does it interfere with those business operations? So by making that accommodation or granting that accommodation, would it require some sort of fundamental alteration to the nature of the provider's operation? So would it completely change the way you do business? Then it may not be reasonable. Again, this is going to be something that we're going to look at very closely because it really is going to be, again, very fact specific, very case specific on if it is truly reasonable or not. So if a respondent is denying an accommodation request because they are stating it's unreasonable, make sure to look very closely and or consult with some sort of attorney to ensure, is this an actual reasonable declining of the accommodation? These are the reasons why we're doing it. Is that permissible under the law? Working with tenants can usually go a long way. It kind of goes without saying, we unfortunately do not see a ton of tenants that are thrilled about their tenancy. They've had a great time living at the residence that they have, but they just felt that they should file a complaint. It's not to say that all of them are upset with their landlords or upset by the situation, but generally speaking, a lot of them either there's kind of other associated factors, or they are truly upset that the respondent, they don't believe, had either discussed these issues with them, kind of discussed the outcomes with them, and sometimes that is the reason that they filed the complaint with our office. So speaking of upset, this is when we get into the kind of icy topic when it comes to landlords specifically, which is service animals. Service animals is one that we see a lot come through our office, and it certainly is one that is a bit of a passion point, I would say, for a lot of landlords and management, because they see a lot of things come through with relation to service animals. So service and assistance animals. Individuals who are disabled may require the use of a service and or assistance animal. The disabled tenant may ask his or her landlord for a reasonable accommodation in the no pets policy. So even though a facility may be a no pets building or a no pets property, they may be requesting that accommodation or that alteration to that general policy related to no pets. So again, to deny that accommodation request, the landlord would have to prove that such an accommodation is not reasonable, not necessary, or causes that undue burden to the landlord. So when it comes to these kind of requests, we see them, like I said, very, very frequently. But there's things you're going to want to really take a look closely at it, because as you all know, there's something that we see a lot more and more of, and it's related to it's really as a whole just a reasonable accommodation request, and that's how it should be looked at and just handled on a kind of situation to situation basis. There may be a variety of different types of assistive animals. So just because an individual comes to a respondent and says, I have the need for some sort of assistance animal, it's a snake, even though it might be something that is not common or not what you would think of as potentially as being, comforting in any sort of way. If that is the kind of medical requirement, if their physician or their doctor or their nurse assistant believes that this is what would be best for their condition, it may be a variety of different kinds of assistance animals. It's not always, when we talk about service dogs, specifically service dogs that have specific training, those are very limited to what kind of animal, but something like an emotional support animal, it may have a few other variations to what we think of as the kind of the common or more known service animals. According to the joint statement issued by HUD and the Department of Justice on May 17th of 2004, housing providers may not require persons with disabilities to pay extra fees or deposits as a condition of receiving a reasonable accommodation. When we talk about animals in a property, the individual or the property cannot charge them additional fees as a condition of receiving that reasonable accommodation. So a pet deposit, anything of the sort, because it would be similar to if the individual, let's say, had a wheelchair and the respondent is charging them an extra fee to ensure that they don't damage the property. It's an assistive device. Think of the animal as being an assistive device for their disability. If they are, truly a service or an assistance animal and have that documentation as far as the requirement that they need it for their disability, it's no different than having a wheelchair or something that assists in that disability related function. HUD also issued a notice concerning service animals on April 25th of 2013, and they actually have additional information on there from 2020 as well. They just put some up. HUD's assistance animal and service animal documentation and they're kind of those notices, those general notices and joint statements are very helpful. So if you're really not sure kind of where to start with service or assistance animals, it's a very quick read. It's simple kind of question and answer format. And I think it's very helpful, especially kind of getting your brain around that difficult nature of what exactly a reasonable accommodation related to a service or assistance animal is. So the Department of Labor uses these same documents as far as like those joint statements, anything of those issued by HUD that again, they're available for the general public, but we use them as guidance in our own cases regarding reasonable accommodations. Obviously, we have the laws themselves to go off of, but the thing about the law usually is stating what the parameters of the law itself. There's a lot of room for interpretation within that, and that's where we go to past court cases, past court opinions. We go to these joint statements of what is kind of the intent behind the law. Basically, it's kind of that reading between the lines of what the actual law means. So when we talk about some of the issues that are brought up during any sort of reasonable accommodation related to animals issues with reasonable accommodations, the one that comes up frequently is direct threats. Big thing with direct threats is you're going to really want to make sure that you have actual either tangible proof or reasonable suspicion to believe that there is going to be an actual direct threat to the individual or to your other tenants. This cannot be speculative. It cannot be a suspicion that based on, what type of breed it is or what kind of animal it is you suspect it may. You're going to have more tangible evidence that, based on this specific animal's history, we do believe that there is a direct threat. Again, it can't be speculative. Common areas. Again, this certainly can impact common areas. It's not always going to be specifically to the individual's unit. As we all know, especially, for example, in the winter, if they come and go frequently from their apartment door on a ground level when they take the animal out, but in the winter, snowed in, they're unable to do so and have to go through the main corridors. That could be an example of common areas. Basically, when you're looking at those common areas, big thing is, again, if you're telling them they cannot enter certain common areas for certain reasons, if they're requesting reasonable accommodations, you're going to want to look at that, because if the individual has a disability, you don't want to limit their enjoyments and use of the property more than other tenants. So by restricting them to certain areas or from certain areas, you may be restricting their enjoyments of the property versus individuals who do not have disabilities. You can absolutely have expectations of behavior, keeping the animal clean and healthy, making sure that it's under control, making sure you're cleaning up after the animal. You can certainly have expectations of behavior even for service animals. Just because it's a service animal, it does not mean, or a assistance animal, it does not mean you don't have to have any expectations whatsoever. But again, if you're having kind of those overreaching parameters, that's where you're going to want to look at it very closely, because am I making it unrealistic to be able to even have an animal because of my expectations that I'm putting out for it? There may be city restrictions that are breed restrictions within counties, within cities. Those are a very slippery slope. They're kind of that weird gray area where a city may have restrictions on certain breeds, but that's going to really be an issue with the tenant and the city or the county, whoever has the restrictions. You as a landlord, if let's say they have the animal on the property, generally speaking, it would be an issue that the city would take up with the owner of the animal, not with the building itself. We certainly have seen those kind of complaints come through. And generally speaking, again, just the reliance on we denied the accommodation because there was a city restriction on it may not be permissible under the law. And then the requirements of the animal to be spayed and neutered, certain breed restrictions, weight limitations. Again, those are going to have to be very careful with any sort of overreaching expectations that are requiring certain parameters on a service or assistance animal. Because again, it is truly a reasonable accommodation. It's something that's assisting them with the disability, and you don't want those overreaching parameters that are so restricting that the individual cannot have the same kind of enjoyment, or that you're putting it too burdensome in order for them to have their accommodation. So what if another tenant also has a disability, such as allergies, that won't allow for the service animal to be in the unit? Let's say the next door neighbor has severe allergies, has a lot of concerns about this service or assistance animal coming into the property. Those are where you're going to have to look at each different request for accommodation on a case by case basis. So if the tenant next door is saying, due to my severe allergies, I can't have the assistance animal next to me. And then the individual with the animal is saying, due to my disability, I need to have the animal. You have two kind of competing disabilities, and you have to try to make accommodations for both individuals. So you may have to get creative, may have to look at other kind of solutions potentially on how to make those reasonable accommodations work for both tenants. It's certainly not easy, and there's no easy 1, 2, 3 guide on how to do that. But this is a perfect example of every time you receive those reasonable accommodation requests, they really should be looked at on a case by case basis. The blanket policies or the blanket, kind of expectations of, if an individual has XYZ disability, this is the accommodation we always grant. They're not necessarily always going to work that way, because there are certainly specific situations or circumstances that may completely change the outcome of the case. One that I just point out, and it's more, you don't have to necessarily read through the entirety of the law, but a couple of years ago, Century Code 471607.5 was put into place. And basically, it was initially put out there to eliminate any of the online documentation or questionable documentation. Really, the big purpose behind this is ensuring that there is some sort of reliable supporting documentation. The one thing about, and as I kind of talked about it, when we use words such as like reliable supporting documentation, it can be kind of open to interpretation. And this one we have not seen come through our office too often as an argument of whether or not it was reliable or not. But I think this certainly is going to be something that will eventually come through in a case or two in like the Supreme Court or maybe on district court level, to determine what exactly is the intent behind the wording of reliable supporting documentation, because that may differ from person to person, just as it may from judge to judge. So I think it's going to be something that over time we will get a little bit more of an established baseline of what that reliable supporting documentation is. But that whole purpose, again, is trying to ensure that there's not just the, individuals paying for a doctor's note or paying for something that provides for a reasonable accommodation. So you get all of these reasonable accommodation requests. Can any of these requests be denied? Absolutely. You can deny reasonable accommodation requests. Again, they may be that they aren't reasonable. It may be that it's going to impose some sort of undue hardship or financial burden or administrative burden on the respondent. There are absolutely reasons why a request could be denied. Again, this is where you really want to look at that undue or that case by case basis. If you're going to say that it was an undue hardship, why? What exactly is the reasoning behind it? So look at the specific circumstances, the specific, facts in that exact request before you deny or approve or deny any of those requests. But absolutely, respondents can they can deny any sort of reasonable accommodation request within the parameters of the law. So again, that undue hardship, the big things we're looking at, does it impose that undue financial or administrative burden? But making that accommodation require that fundamental alteration of the nature of the provider's operation. So those are big things that we look at. Again, if you're going to use the direct threat statement of you believed that, for example, the animal was direct threat to that tenant or to other tenants on the property, you're going to look at, was the nature and duration and severity of the risk of injury, the probability that injury will actually occur. Again, these are not going to be based on that stereotype or speculation or fear. Really, you have to have good supporting documentation or reasoning behind your denial if you're going to say that it was a direct threat. And then, were there any other accommodations that might eliminate that direct threat? Were there any other ways to handle that reasonable accommodation request that wouldn't have posed a direct threat? Those are all things that you should consider and take a look at when you're looking at potentially a direct threat situation. So people always get a little bit fearful when it comes to requesting additional documentation for anything disability related. So can a landlord ask for documentation? Maybe. Generally, the housing provider, they can require or they can request or inquire about the nature and severity of the, or they cannot require any information about the nature or the severity of it, but they can request details about what the disability, what exactly are the substantial limitations, if they need to get documentation to see if they even fall within the realms of what the Act's definition is. So under the law, are they a person with a disability? If the request or the information that they provide states, based on my, knowledge of this individual's disability, they are a disability under the Act. I do believe that they need this certain accommodation for their disability, and shows that relationship between the disability and the disability requested need. That's really all that you can have. You really shouldn't be acting as the physician or the doctor in these situations and assume that you need additional information if really the accommodation is clear. If the documentation received for an accommodation request is not clear, you may ask for additional documentation that verifies the presence of the disability and or explains that specific connection. But again, you are not the doctor. If it makes that clear connection, even if you're questioning whether, do they really need this one? Do they really need these items? If the documentation truly demonstrates, again, that disability and the disability need for the accommodation, that's really what you're going to be able to request. So big things to keep in mind when it comes to those accommodations or modifications. Again, it's not always going to be a clear and concise statement or on that prescribed form. So know when a request is being made, know how to identify it. If you have any of your team that is working with tenants, working with the general public, make sure that they're kind of aware of what reasonable accommodations are. So if they hear any of these kind of leading towards a reasonable accommodation request, either they know to start listening for what details are being provided, or they know how to direct them to whoever is needed to help provide that information. Respond promptly. Again, those undue delays may be deemed as a failure to provide an accommodation. Basically, what the law indicates is that if a respondent does not respond in a timely manner to a request, that in and of itself could be a delay or a denial because they did not need to provide that extension of a delay. The big thing under the law, there's not a set time frame. So it doesn't say within 7 days, 7 business days, they have to provide a response. Again, it's going to be a case by case situation, but you really want to keep in mind anytime you're going to, kind of not respond, or someone's out of the office and you're like, well, that's their problem, not mine, even though I'm on the email, make sure, even if it's just a quick email back to the individual and say, yep, we're taking a look at it. We received it. We will get back to you. But make sure you're really working through those requests in a prompt manner. Think about dance when it comes to reasonableness. So disability. Does the tenant have a disability as defined by the law? Accommodation. Is the tenant requesting a change in the landlord's rules or practices? Is it necessary? So is that accommodation or modification necessary for the full use and enjoyment of the property? Cost. Does the accommodation or modification impose an undue financial or administrative cost related to the request? And the last, effect. Would the accommodation or modification affect a fundamental change in the landlord's business? So that's kind of just dance. That's what it stands for. Just thinking about those reasonableness factors. And then again, as soon as you determine a request is being made, make sure you stop, listen, take notes, make sure you're getting any of the information that you need so that you can best respond to what that accommodation request is. Another big issue that we see come through our office frequently, retaliation. I provided here just again the dictionary definition, but there is a difference between the dictionary and the legal, but generally it's about the same. Retaliation, the action of harming someone because they have harmed oneself, or revenge. When it comes to retaliation, we see it in many different forms. Sometimes we see it as I requested a reasonable accommodation, and as a result, they decided to issue me a non-renewal notice. Or maybe it's even a step further that, I believed I was discriminated against. I filed a complaint with your office, the Department of Labor and Human Rights, and after I had filed that complaint, they started harassing me, or they issued me a non-renewal notice because I had filed a complaint with the department. Those can be all forms of retaliation that we may see when it comes to issues related to housing. Why would someone retaliate if they know it's against the law? As many of us kind of know from past experiences, of course it's illegal to retaliate against an individual. But in some situations, it may be just because they feel slighted. Oftentimes, it's almost a defense mechanism, this human reaction. If something is being either said or done, like, for example, in the case of having a complaint filed against the individual, it may be a natural reaction for that individual to be upset. The landlord goes, I have never once had a complaint filed against me the whole time I've owned any sort of properties. I cannot believe they're doing this. It may be a human reaction, but again, that doesn't always necessarily mean it's permissible under the law. The individual may believe that there is some sort of malicious intent. Like I said, we don't see a ton of cases come through our office where the parties really have such a great relationship, a great rapport with each other, but the complainant just believes that they had to file a complaint. A lot of times there is a lot of feelings, a lot of upset nature that kind of leads up to these complaints. And so the individual, the respondent that's receiving these, may feel that there was malicious intent behind the complaint itself. The accusations themselves can be very serious. Obviously, a complaint is a serious. Excuse me. Sometimes the individual just, they don't see it as bullying. They don't see it as them retaliating against that individual. They may see the revenge itself is something that may be perceived by the other party, but does not have any truth to it, according to the respondent. Like I said, we see a lot of these cases. I have a tickle in my throat. We see a lot of these cases usually in the form of kind of a dual filed. So because they had filed one issue, subsequently they may file on retaliation as well. We don't oftentimes see it too frequently as kind of its own standalone. I reported discrimination. As a result, they took some sort of action against me. Normally, retaliation's in conjunction with disability, with race. It's usually in conjunction with other categories as well. So we'll move into a little bit of discrimination in publications. So when it comes to publications, a person may not make, print, publish, or affect the making, printing, or publishing of a notice, statement, or advertisement that is about the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on a person's membership of a protected category. So basically, these are, you can't publish anything, again, whether it be making kind of the statement of, or an advertisement, or just writing something that is discriminatory in nature under any of those protected categories under our law. Obviously, we kind of, when you think of publications, you think books, magazines, newspapers, but as you all well know, the current realm of media is much broader than just what it used to be. This isn't just an ad in a newspaper saying, if you'd like to rent from me, make sure that you're of this certain protected category. This can be a lot of different things. It can be Facebook posts, it can be TikTok videos, it can be text messages, emails. It's any written statements, it can be verbal or nonverbal statements, and they're not always ill-intentioned, but it can show a preference or limitation. So for example, if an individual, let's say they've just had a lot of issues with this specific individual or family, and they said, you know what, I am so sick of all the problems related to this. This is why I don't want to rent to families ever again. That could be a discriminatory statement because it's indicating a preference based on familial status, a protected category. So it's something that we see a lot more just because we live in an age right now that so much is documented in some way, shape, or form. It could be recordings or voicemails. It could be, various items that are indicating some sort of preference, and that's really where those limitations or those issues arise. Keep in mind, statements can be well-intentioned, but may not necessarily be legal. It's not often that we see too many complaints that are just outright blatant negligence. A lot of times they're either trying to prevent an issue or they're just making a general statement, but it still may not be permissible. So it's something to very much keep in mind. Same kind of exemptions from publication. So again, those same kind of issues that we talked about, or the exemptions we talked about earlier: housing for older persons, private clubs, religious organizations, and then also for shared living houses. This could be something like maybe apartment areas where there's shared occupants like roommates or dorms, things like that. There are exemptions from certain publication pieces in that. And so there are some exceptions to those publication rules. We look at what the reasonable person standard is, because again, one statement to one person could seem discriminatory in nature, but it may not seem discriminatory to another person. So in determining whether a publication constitutes a discriminatory housing practice, the courts have generally applied that reasonable person standard, which means that if it's readily apparent to an ordinary reader or listener, that can be where the problems lie. So if a readily apparent discriminatory in nature it's easy to see from any ordinary reader or listener, that's generally what's going to constitute a violation. Some of the things to avoid, again, really showing that preference. These are just a couple items on a list of items that you should be straying away from, especially if you're talking about maybe a property that's available I'm looking for a tenant that has no children. I'm looking for a Christian tenant. I'm looking for somebody who is a physically fit person. Because maybe it's on a fourth floor apartment with stairs and you're looking solely for somebody to be able to get up there without any problem. Um, Mentally ill individuals need not apply, things like that. Just really be cautious of those emotionally charged conversations too with tenants. So things that may be said during a conversation with a tenant easily can really get upsetting in nature for both parties, and a lot of things may be said, but you really want to be mindful of what you are saying, especially to tenants, because again, in a day and age where it's so easy to record conversations, it certainly can be used to be problematic in the future if they are to file a complaint. Big thing with publications to keep in mind in general is always be describing the property itself, not the person within the property you want. So if you want certain kinds of tenants to be in your units, don't describe the type of tenant you want. Describe what the property itself is. That's, when it comes to publications, probably going to be the easiest thing to keep in mind to prevent any of those discriminatory statements from occurring. So I'm notified a complaint is filed with the department. Now what? What happens if a complaint is filed? Aside from potentially instant panic for some people that get the complaint, take a breath, and this is kind of what the process is. So whenever we receive a complaint, the initial step is the complainant completes what we call an intake, and they send that intake to our department. What that intake comprises of. Basically, it says, this is what I believe occurred. This is what I believe it was based on, whatever discriminatory category it was based on. These are the details about the property. Basically explains a little bit about the actual situation and why they believe that they were discriminated against. At that point, the intake it's issued to one of our investigators and we evaluate it. What things we're looking for. So we're looking at, can we establish jurisdiction? So does the complaint fall under any of our protected categories? There are a lot of intakes that come through our department that really are solely landlord-tenant issues. They're not discrimination issues. They are just, the landlord won't come and repair my moldy shower, or they aren't, cleaning my carpets frequently, whatever the case may be. They may be landlord tenant issues that we have no jurisdiction over. We only have authority and jurisdiction over those discrimination complaints of anything that's based on one of those protected categories or retaliation for what we call participation in a protected activity, which is filing some sort of discrimination complaint, participating in a discrimination investigation, or requesting a reasonable accommodation, requesting a modification, requesting a religious accommodation of some sort. Those may be all pieces of what we call participated in a protected activity. So they have to fall under one of those categories in order for us to file the complaint. Other things that we look at, we're looking initially jurisdictionally, are they even a respondent under what we have? Are they any of those exemptions? Right off the bat, kind of looking through them. Is it a Mrs. Murphy's property? Are there only, a duplex and the owner lives in the other property? Then it may not be our jurisdiction. So we're all looking at those pieces to establish whether or not we have jurisdiction. The other big thing we have with relation to jurisdiction is going to be, did it occur within the statute of limitations? Statute of limitations for a housing complaint is 1 year from the discriminatory action. So if they were evicted last February, that's not going to fall within our jurisdiction. We're unable to proceed forward that complaint. If it falls within our jurisdiction of happening, a few months ago, we certainly may have authority to write that complaint. So once we establish that jurisdictional piece, we write a summary of the allegation. So we're writing what we call a complaint, and it is just a summary of what they're alleging happened. It's not that the department, when we issue that complaint out to the respondent to respond to, we're not saying, see, this is what they said happened, and we believe that they're right, provide us a response. We are always going to act as a neutral middle party. So we are just establishing what happened based on both sides. So we receive the complaint. If the allegations are within our jurisdiction, we have the authority to write that summary. We send that to the complainant to review. They review it to see if everything's accurate and correct. If it is, they sign it and return it to us. And that's what officially opens a complaint with our department. So then we have an actual open case with the department. Then we send that complaint, that summary of the allegations, to the respondent, and we request a response. So that's us saying, here was the complainant's side of things. Now, can you provide your response to this, your side of things, and provide the supporting documentation? So providing any of that documentation that explains kind of why you came to the conclusions you did, what exactly occurred, anything of the sort. Once we receive the response from the respondent, that's when the actual investigation starts. So we do an investigation and we determine whether or not what had occurred is a violation of the law or not. And so we are looking at all of the facts and circumstances. We're looking at the federal law, we're looking at state law, past court cases, and determining if what had occurred violated the law or not. Ultimately, once we make that decision, we issue out what we call a determination, and that determination explains our findings. We do have conciliation emphasized throughout the process. So throughout, from start to finish, from the time that the complaint is actually filed all the way through until the time that we issue that determination, we do allow for any sort of conciliation discussions throughout the way. So what exactly is conciliation? Those are going to be those informal negotiations. So they're informal back and forth possible resolutions between the parties. Again, the department just acts kind of as that middleman. We act as a neutral party, and we can certainly help facilitate those discussions. They don't necessarily have to be a formal, like, sit down mediation. It's a lot of times it's just going to be informal offers back and forth. So the complainant may say, this is what I'm seeking to try to resolve the case. We would pass that along to the respondent. They can accept the offer, decline the offer, or provide a counter offer. And that back and forth goes on until hopefully we come to some sort of resolution. And if they do come to some sort of resolution, it results in an agreement with our department. The proceedings themselves, so any of the conciliation discussions, any of the offers that go back and forth, they are confidential. They're not something that's part of open records, anything of the sort. Obviously, we can, when we work with HUD, those things would be something that would be passed along because they're part of the case file itself, but they're not going to be something that would be submitted for open records requests. Either party can certainly have any representation if they wish throughout the process. So they can get an attorney to provide their response. They can have an attorney to be present for any sort of negotiations or pass along negotiation offers, but it's not required. Either party can have that, but they're not required. The conciliation discussions is voluntary for both parties. If the complainant says, here's the offer I want to send over to them, I send it to the respondent goes, I don't want to go, I don't want to respond to the offer, and I just want to move forward with the investigation. They absolutely can do that. Again, kind of as a requirement for us as a department, if we have those discussions going on, if one party says, no, I don't want to conciliate it, I don't want to have these resolutions, I just want to move forward with the investigation, we absolutely can do so. But if later down the road the complainant says, well, can you just throw them this last offer back to them, we can still continue to provide offers if additional ones come down the road. But again, there's no requirement to say yes or no to them. There's no requirement to participate in them. If that further down the road, the respondent still doesn't want to proceed forward with that, they can absolutely say no. Again, those agreements, if we do come to a resolution and we put together an agreement, and those agreements are binding. Big thing about the conciliation agreements with the department is they're kind of twofold. One piece of it is that we always have what we call relief for the complainant. So that would be relief specifically for the individual that filed the complaint. And then also there's relief in the public interest. And the whole point behind the relief in the public interest is basically to further and expand and ensure that the fair housing laws are being understood, that they're being practiced. A lot of things that go on with those kind of relief in the public interest, those could be trainings. They could be things that are distribution of brochures, maybe reviewing their policies to ensure compliance. Those can all be things that, again, are furthering and expanding the purpose behind the fair housing laws, and they're kind of that relief to the general public. So once we go through that investigation and we issue that determination, basically it's going to go one of two ways. Either we believe that based on the facts and evidence, a violation of the law did occur, or based on the facts and evidence, a violation of the law did not occur. If we believe that a violation did occur, we do what we call issue a charge. And so basically a legal document indicating that we believe a violation of the law occurred. And then thereafter court proceedings would occur. There's always, again, conciliation can certainly go on even after a determination is issued. But if we believe based on the facts and evidence a violation of the law did not occur, then we would dismiss the complaint. So we'd issue out the determination to the parties and we would close the complaint thereafter. There would be no further action. The complainant can always pursue the issue through district court on their own, but there's not a specific appeals process or anything of the sort through the department. department. Once we've made our decision and dismissed that complaint, the complaint is closed with our office. So the role of the department investigator. So myself as an investigator, always conducting a fair, impartial, and thorough investigation into the facts and circumstances. Basically, again, always acting as that neutral party. We're never on the complainant's behalf. We're never on the respondent's behalf. We are just taking the facts and circumstances and determining if a violation of the law occurred. When we go through that information, it's going to be a lot of just information gathering. It'll be additional interviews with various parties. It could be with witnesses. It could be with other staff members. It could be requesting additional documentation. So one thing that the department does frequently is we request what we call comparative information. So what happened with other circumstances that were similar to this? Have you ever, issued noise infractions to other tenants? If so, what happened? What was the circumstance? What was the race of that tenant? What was the familial status of that tenant? If you've issued other notices of non-renewal, what were those other circumstances? What occurred that resulted in you issuing those non-renewals? And what were those individuals' protected category? And we're just looking at it to determine, what was the respondent's kind of practice or policy related to non-renewals or noise infractions. It's just looking at what the actual practices were, because sometimes what their policy is on paper isn't always exactly how they actually transpose it into kind of their business practices, and that's what we're looking at. So a lot of just additional information gathering from both sides. We perform additional interviews with the parties, and then again, ultimately, we issue out that full written report of our findings. So that determination explains exactly how we came to the conclusions that we did. So we collect the facts and circumstances to answer, ultimately, is there reasonable cause to believe that the respondent committed an unlawful active housing discrimination or not? That's ultimately what our purpose is. Kind of our end goal is, we've got these allegations. We determine of those, what actually occurred and was that in violation of the law or not. When it comes to the housing investigation, they can be extremely lengthy. It can be kind of a time committed process, only in the fact that we may have a lot of additional information we need or a lot of additional back and forth between the parties. Sometimes that conciliation process, the back and forth of offers, that in and of itself can take a great deal of time, where the parties are really going back and forth and deciding if they want to resolve this more informally or not. And sometimes it can be that we've almost completed the entirety of the investigation, and then the parties do wish to kind of re-engage in that conciliation talks. So investigations, they can be shorter, they can be longer, and there's really not a great timeline or time frame when it comes to investigations, because it's really dependent on the facts and the circumstances, as well as how many parties are involved as well. So how do you know what not to do? Obviously, it's always easy to say, well, this is the information I've been provided. I don't know how, honestly, to actually apply this in my day-to-day work. Get educated. There's a lot of great resources when it comes to housing discrimination and what fair housing is. But things like this, these are great ways to have parties be able to kind of respondents specifically be able to get more knowledge and more insight into what these investigations are, how we go about kind of evaluating them, and things to prevent having occurrences in the future. Unfortunately, complaints can be filed regardless, no matter whether we believe a violation of law occurred or not. You can have a housing complaint filed against you if their allegations fall within our jurisdiction. And it's not something that necessarily should be completely a panic moment. Sometimes it is a great learning exercise, even of, okay, these are the things that we have set out to do and we are doing them, or these are some rooms for improvement. So it's always, I think, getting educated on knowing what to expect, what to know about these fair housing laws can always be very helpful, because the laws themselves, especially if you open up the actual law, it's very daunting. It can be very overwhelming. It can be very hard to get through. I myself, again, I do this on a day-to-day basis, and the laws still are daunting to me. So it's one of those things that just getting educated, especially in more of these kind of formats where someone can explain a little bit more on the law, can certainly help point you in the right direction. Visit our website and HUD's website. Like I said, on kind of the reasonable accommodations, those service animals and assistance animals, HUD actually has some wonderful information related to really a question and answer guide. I know that they just recently have put out some information that really is a kind of a yes or no guide of, all right, this is what's being requested. What should I do next? Just really scrolling through them, looking at them, just knowing that they're out there can be extremely helpful. I know a lot of, especially when it comes to kind of federal laws and guides, sometimes they can be a little overwhelming or not very helpful. But I will say HUD's joint statements, HUD's information really does provide you some great insight onto why they have some of the laws that they have, how they look at some of those laws. And I always say be mindful with things like Google, but it can obviously provide you some great information as well, so long as it's reputable sites. But HUD's website really, it can be kind of burdensome to navigate sometimes, but using those search bars, using Google and finding which ones are related or associated to HUD, you can find some really great information about reasonable accommodations, service animals, about issues related to, whether it be limitations on breeds or things like that. They have a lot of information, and there's a lot of information about past court cases that I always think is a little bit helpful. Kind of just understanding what past court cases have determined in similar type of situations. But the big thing to remember is if you aren't certain or you're not sure, make sure you visit with an attorney that's knowledgeable in fair housing laws. You may have a wonderful attorney that you've used for family cases, for divorce cases, whatever the case may be, but you really want to find somebody who is knowledgeable in fair housing laws. Like I said, it can be a real swamp to get through. It is a lot of different facts that kind of play into these decisions. There's a lot of laws associated with it. Like I said, myself included, almost 10 years in, I still think it's overwhelming at times. So really find somebody who is well versed in these fair housing laws, that has dealings with fair housing laws, and they certainly can point you in the right direction. It's always difficult because you can contact the Department of Labor, ask questions. We definitely try to provide you great answers and kind of point you in the right direction, but we cannot provide you any sort of advice or guidance. And as I've explained probably too many times, but these are very, very fact-specific situations. One piece of it could entirely change what the outcome of a case is. And so that's why really we just legally, we can't provide that advice or guidance, but an attorney can. You can go to an attorney and they can certainly go through the facts that they have and be able to give you those actual legal opinions. But when you call our department, we absolutely will try to point you in the right direction. We may, provide you additional information or try to provide you a better answer to what the law is. But that's really kind of the limitation that our department would be able to provide. When it comes to the recommendations for the department, and it's kind of leading to the end of things, we really have so many cases that documentation is absolutely key. Document everything. Honestly, if everyone documented as much as they could, it would make my job a lot easier. In a day and age, again, where so many things are easily documented, text messages, emails, any sort of messages, really document these type of things as far as reasonable accommodation requests, making sure that you're documenting that they're occurring. If you're making any sort of decisions, make sure you're documenting them. If you're having infractions or issues with tenants, making sure you're documenting them. We see it a lot with employment where, an employee gets fired and they go, well, they were terrible. They were a horrible employee, yet their performance reviews were outstanding. They were always great. They don't have any write-ups. Same goes with tenants. If you have kind of nothing of a trail and you say, well, we had to get rid of them because they were awful, it can be problematic if you really don't have anything kind of documentation wise to be able to actually prove that or provide supporting documentation for. So document everything. It can be a little burdensome at times, but it certainly can help you if a case is filed. Avoid those sudden rash decisions. Make sure you take time to think through and evaluate a request prior to jumping to the conclusion and stating no. Kind of the simple answer I have for this one is think of like a testing case. If you got a phone call and an individual says, well, I have 7 assistance animal dogs that I want to live in the unit. And you go, oh, absolutely not. We would never do that. That can be problematic. If the individual is saying, I'm a person with a disability, I'm requesting this reasonable accommodation, and your instant answer is no, with no reasoning as to why, that those can be possibly problematic. So make sure you stop, kind of think before you provide instant responses. Make sure you have either some reasoning or kind of documentation behind what your reasoning is and why you're making that response. Likewise, again, if the individual is requesting something that you may think is unreasonable, but really once you evaluate the information, either you determine there are other accommodations that might be effective for the individual, or let's say you may be reviewing their information and realize that, oh, I guess I didn't realize that that's what you were asking for. I can indeed provide that. Just make sure to really think through those decisions before you instantly make that response. When it comes to training your managers and staff, do it tenfold. Touch base a lot. The one thing about any sort of employment anywhere, when you first start at an employment, you usually get this huge handbook of all the ways that all the policies, all the ways you should deal with things. And it may be something that you don't necessarily always go through at the time of. It might be something that, hey, can you just read through these when you have time? They may never read through those. So touching base with employees frequently about what policies are, what expectations are, can certainly be helpful. But equally, you may have employees that have been there for years and years, and they have always done this certain practice this certain way, but it may not be really either permissible under the law, or it may not honestly be in line with what your practices and policies are as a business. So making sure to train your employees, make sure you talk to your employees, even if it's just a touch base once in a while of, hey, as a reminder, if we get reasonable accommodation requests, this is kind of the process that we want to walk through. Any individual that's going to be dealing with the public, you want to make sure that they're aware, because even though they may not be the ultimate decision maker or the individual that would be making those decisions, they may be influencing or they may have a part in the totality of the situation. If they, let's say, somebody comes in over lunch break, and the person who handles all of the tenants, the one who is the main property manager's out to lunch, and maybe a leasing associate or somebody of the sort says, oh, well, I might be able to help you. They have some sort of request or make some sort of statement that is discriminatory in nature. That could be problematic, even if that person generally doesn't handle tenants. So any individual that may be dealing with tenants, just make them aware of what discrimination is. Make sure that they're aware of, how to respond to reasonable accommodation requests, or responding to any tenant, to make sure that they're not, making these discriminatory statements, that they're not, saying no to a reasonable accommodation request without any sort of evaluation of the information. So really training your staff will be helpful in the long run. And I get that among the million of other things and hats that they have, that they wear each day, I know it can seem burdensome, but really it will help prevent issues and problems kind of going forward into the future. Again, know the law. Just if you don't know the law, contact an attorney with experience. Make sure you contact somebody who does have experience with the law, who does know the law, and ask those questions if you're not sure of it. Again, all of these kind of the guides, the HUD information, the brochures, they can be extremely helpful. But at the end of the day, if you're not sure if that's the right decision or not, double check it. You will hands down appreciate it in the long run, because going through, again, a department investigation, or if we do issue a charge that we do believe a violation occurred, it really is a lot to deal with. It can be very lengthy, it can be very time consuming. So really making sure that you're clear on those laws up front can always be helpful. Being consistent, obviously making sure, like I said, to not treat other tenants differently solely because of protected groups. Really, if you're very clear and concise on what your policies are, what your practices are, and you stick to them, it's a lot easier to say, regardless of whatever protected class they're in, anytime they get 3 noise infractions, they're issued a non-renewal notice, or whatever the case may be. There may be, very specific parameters that you are sticking to, you are keeping it consistent. Again, you may have accommodation requests or things that come up related to disabilities that can certainly play into that or impact it. But as a whole, the more you're consistent with all of your tenants, the more your tenants will know what's expected of them. But they also, it's a lot harder in an investigation to determine that, oh, you were absolutely singling that person out because you were consistent throughout. We were always, this is how you've always handled any of those issues. Be nice. Again, it sounds a little ridiculous, and it shouldn't have to be said this way. But again, we don't have a lot of tenants that come to our office saying things worked out wonderfully, but we just felt we needed to file. If you're, nice and you communicate, you let them know what's happening, what's going on, it certainly can help things in the long run. Again, making efforts to make those reasonable accommodations, if at all possible. I get it. It's not always possible, and you have the right to deny accommodation requests sometimes, but trying to work with those tenants and really trying to come to some sort of solution really will help both parties. Shelter is kind of one of the 5 main levels of human living. It's something that is needed to survive. That food, air, clothing, sleep, those things are necessary for humans to live, and shelter is one of those. So when it comes to these issues, a lot of people it's so emotionally charged because this is one of their basic human needs. They need somewhere to live, and it's somewhere we spend a lot of our time. If we are unhappy living there, if we're upset living there, it can make it very difficult. And so I think, just like I said, it's not going to always work. We know how humans are as a whole. I know how myself at times can be, you have a bad day and sometimes it's not as easy to communicate well, but really working with tenants and making sure that they're aware of what's going on and really trying to find solutions certainly can help things in the long run. When it comes to ultimately the defenses, one thing that, again, knowing the law is one thing that I always say, I didn't know is not a defense that's realistic. We're not going to ever say, well, the respondent wasn't aware of that was the law. Unfortunately, it is an expectation that if you're running a business, you know what the laws are that apply to you. And sometimes it can unfortunately be a learning lesson that if a complaint is filed and we do find a violation, really take it as such, take it as a learning lesson and prevent it going forward in the future. But just not knowing that that was the way that the law was is not going to ever be a permissible kind of excuse for any sort of complaint. The only other thing, and we really don't see it, I guess, as commonly right now, but we did a couple of years ago, and I always just touch on it. There may be accommodation requests that are kind of more situational, I guess. When we had COVID, when kind of COVID occurred and we had such an influx of cases, that's one that we saw that occasionally could be a disability, occasionally not, but it is something that we saw requests for accommodation. And if there are things like that, you really, again, want to kind of take it on that case by case basis, evaluate what the request is, how it is some sort of disability, how it's impacting them as a disability, things like that. So always be aware that even if it's not necessarily, again, what you think of as a main disability, it may be something that's being requested as an accommodation. So with that, we can go through any questions. This is all of the department's information. Like I said, it can be frustrating. Sometimes we can't provide exact answers to questions, but we can absolutely try to better explain the law. We will point you in the right direction or try to get you on the right track. Despite the fact that we're the complaint people, we really are good people. We try to provide you guys the information that would be helpful and kind of point you in the right direction with any of those housing related questions.
All right, we do have a couple questions. Can a puppy be considered a service animal?
It can. It really is going to depend because, again, this is where that definition between service animal and assistive animal can be differing. A service animal, generally speaking, is very specifically trained for certain functions, and it could be a puppy. It may be a puppy. It's just it really is going to depend on what their kind of service. What service it is they're providing for the disability and what kind of training they have, but it certainly could absolutely be an assistance animal. Again, kind of the easy one that most people think of as an emotional support animal is one that frequently comes to mind when it comes to like puppies or other animals that might not necessarily come to mind of fully trained animals for a disability.
Um, can we limit the number of service assistant animals a tenant can have?
Not necessarily. Again, this is where that case by case basis is really going to be important because it's going to depend on what documentation they have. So let's say their doctor's note indicates they have a need for each of those animals based on their disability. So this animal is performing this function for them, this one's performing this, and their doctor's information may not say all of that, but if they have kind of medical backing that yes, they need these three service animals, that may be that they need the three for their disability. So a respondent could not limit saying, no, we only allow two, even though their documentation says more than that. But when it kind of gets, I guess, in those higher numbers, oftentimes that's where we look very closely on what is the medical documentation, what is that medical necessity for that many. So there may be some animals, like some animal types, that truly are meant to live in pairs. And so two may be necessary because as a whole, that kind of animal needs to have a mate or a pair with it at all as kind of its function. But otherwise, when it comes to limiting, you really want to be careful because again, if there may be exceptions to that, there may be times where the medical documentation actually shows that they do need more than two, maybe more than three, maybe more than four, whatever the case may be, they may have medical documentation supporting that.
If our insurance does not allow pit bulls, but their doctor note allows them to have it for emotional support, what do we do?
So there is actually a specific kind of question and answer form on HUD's website about like insurance companies and kind of what those limitations are. Really, what is looked at a lot when it comes to insurances is it's sort of that undue hardship piece of it is what is closely looked at. And it is going to be something that we would look at what was the insurance company either going to cancel the insurance policy or fundamentally alter the insurance policy? And if so, what was the availability of other policies, similar policies in the area, or what was the feasibility? Really, it would be kind of that undue hardship. So would it be fundamentally altering the business? Would it be an administrative burden or a financial burden that would be just infeasible for them to permit that animal? That's kind of where it could go as far as the insurance piece of it. Hope that answers it.
Um, a lot of people go online to certify their animals. Are those acceptable?
It's going to depend. The one thing that's gotten very difficult since COVID with kind of those online certifications is there may be, especially with telehealth, things like that, there may be an individual that's absolutely qualified to certify that animal as being needed for their disability without them necessarily seeing that person. So it's those, I think, in fact, are even harder than they were 5 years ago because of the fact that telehealth, you could have providers in different states that have never actually necessarily met you. But let's say it's therapy reasons, maybe mental health reasons that you need this service animal, they may absolutely be qualified to submit documentation saying that this individual needs a service animal, even if they've never necessarily actually met that person in person. But it is something that's where I think that law regarding the reliable supporting documentation, I think is going to have questions come up in it, because that really was what the nature of it was, is to hopefully eliminate or prevent some of those. I paid $30 and I got a doctor's note saying I could have an animal. But as a provider, as a landlord, you want to be careful with those of denying them just solely on, well, I don't believe that this is a letter that indicates that they need it. So I don't know that you don't necessarily want to be the one making that call on whether or not that's enough or not.
Kind of a follow-up to that one. Do they need to have new letters each year to prove they still have the need for a service or emotional support animal?
Not necessarily. I mean, it's one of those. This is one question that we get a lot, and there is information about it, that it basically, again, unless you have either reason to believe that the disability has changed or altered or anything, if it's something that's an extremely outdated letter, sure, that may be, hey, I see this is from 2000. Can we have an updated note? There may be reasons why you would request one, but requesting one each year may be, again, kind of putting that undue hardship on the person to have to seek services from a physician each year to get it. So you just
Does
want to be careful with that.
does the tenant with a service or support animal need to have a specific insurance writer or coverage for the animal? Or does the landlord leasing agency need to obtain one? Can they obtain one?
That again is going to kind of go to that expectations that you're putting on someone else. It's similar to requiring them to have a pet deposit. To have them have a specific policy solely for the pet, maybe requiring them to have additional things that a normal tenant wouldn't. So kind of requiring them to have above and beyond what a tenant that's not disabled has. So again, you'd want to be very cautious of anything related to that. And really, a lot of that's going to come down to your insurance policy. So if you require renter's insurance of all tenants, sure, you could absolutely have, requirements of certain of coverage, but to say if you have an animal in the unit, you have to have this additional coverage. Again, for service and assistance animals, that's putting that additional expectation on them that is not usually permissible by the law.
A former tenant used the two-bedroom for storage with Tupperwares, etc., but slept in the living room, which also had totes. They want to move back. Can I let the manager know about the former hoarding and it cannot happen again without sounding discriminating?
Well, I mean, I guess it would depend, I guess, if their hoarding was a disability or if they had some disability related condition. Obviously, you wouldn't want to necessarily, you know, provide that information, because that certainly can be problematic that you're releasing the tenant's disability. If it is just, like you had them as a tenant and they were issued a non-renewal, and maybe your practice is that if they were issued a non-renewal for certain reasons, it's evaluated and they evaluate it and decide not to. But you would want to be just careful, like I said, if it's anything in those protected categories. So if it is a disability related issue, that could be problematic, saying, well, we already had this issue before with that person. If it is, again, related to a disability, that could be problematic. But if it was just, you know, they were just very messy and you had problems in the past with them very messy, and that's the reason that they were issued a non-renewal, telling a current manager that they were previously dismissed or issued non-renewals because of their messiness is not going to necessarily be perceived as an ordinary listener that's your preference or anything related to a protected category.
Okay, I don't see any other questions. So I think on that note, thank you so much again for presenting. We always appreciate it. There's a couple questions regarding certificates. So if you're still on, just email Stacy and she can get you out a certificate of completion. We don't offer any CEUs, but she can definitely get you that certificate of completion for participating in today's training. So with that, we will wrap up today. Our next presentation is on trauma, which will be held on May 7th at 1:30. So hope to see you all next week for that presentation. Have a wonderful day.
Thanks, Kylie.
Thank you.